Good evening. Welcome to the very first episode of Talk Law with Monare. This evening, we have a lot to talk about. It's been a long time coming. A number of you might be familiar with my face from the other platform with the legal practitioner, where at this time and place on a Thursday evening, we normally talk, we have our law discussions. So this is a new platform which looks to expand the audience. You know, we want to reach more people. So this is how the platform was given birth to. So today we have a guest. She's a legal practitioner enrolled as an attorney of the High Court of South Africa. She is a director of Matlabane Attorneys, Ms. Millicent Matlabane, as you would have seen from our poster. But she sends her apologies. She will be running late because she's currently busy with an agent application. So she will join us later on, hopefully within the next 30 minutes, because our podcast will take about an hour, which will, as I'm looking at the time, it will end around 8 or 8:15, because we started late, and we also apologize for that. So thank you for joining us tonight, and we hope that our platform will be of assistance to you. You will learn, you will also be gaining knowledge, you know. And the topic for discussion today is very relevant to a lot of us who are watching this, and a lot of us who are still to watch this episode. So the topic for today is twofold, but then, as you'd have seen, or as you'd have seen from the previous episodes, we've been discussing marriage and divorces. Last week we were discussing divorces. So this week it's more a continuation. We're still dealing with estates, you know. So excuse me. Yeah. So tonight we'll be discussing deceased estates, the administration of deceased estates, and wills. So administration of deceased estates, we'll be talking about what happens the moment that a person dies and leave property behind. What happens to their estate? So we'll be discussing that. We'll be discussing that in relation to civil marriages, customary law marriages. We'll be discussing the requirements of reporting an estate to the master's office. Which master's office must the estate be reported to? And then after we are done discussing deceased estates, we'll be discussing wills. We'll be dealing with the requirements of a valid will. You know, how must the will be drafted? Who can draft a will? At what age? What are the statutory requirements in terms of the Wills Act? So we'll be looking at that, you know, because the moment a person dies, their property or their estate will be administered either in terms of a will or Intestate Succession Act. So that is the case where a person dies without a will. So tonight we'll be discussing administration of deceased estates, and then we'll move on to wills in terms of what are the requirements. So, but then before we do that, I want us to just have a brief introduction in terms of the platform. Why are we here? You know, so as you have seen again from the poster, my name is Kgwaedi Monare Setlago. I'm the director of Setlago Attorneys Incorporated, and I'm the founder and the host for this platform as well, which is Talk Law with Monare. And so the purpose of the show is to basically bring the law to the people. We want to give the general society access to the law, because in most cases we find that people can access legal services because of financial impediments, so due to our financial struggles, we are unable to consult with legal practitioners. We are unable to, because some matters, when you go to law clinics or legal centers or legal aid, they don't deal with them, So if you don't have money, you might find yourself with a dead end. So this platform was created to provide access to the law, to the general society, but as well to provide advice to other legal practitioners. So it has a threefold purpose. The first one is to discuss current and recent legal developments. Our courts, the judiciary gives out judgments every single day, and we are lucky enough that some of those judgments, they develop the law, they bring out new laws, they amend the old laws. So as legal practitioners, we need to keep up so that we advise or we provide a service accordingly. So now the platform was created so that we will discuss legal developments as and when they happen, and we'll try our best to do that, because as I said, a lot of our courts give out judgments, important judgments on a daily basis, be it the Constitutional Court, be it the Labor Court, be it the various high courts or magistrate courts, or even tribunals, Competition Commission. So we will be doing our level best to keep up with the legal developments, as well as to give a thorough discussion of those developments. But then the second purpose for this platform is to also profile legal practitioners. We want to create a platform whereby young dynamic legal practitioners can come on and profile their various practices, be it you are an advocate or you are a practicing attorney or you are running a consultancy firm. This platform is for you, whereby we'll be giving you access to a number of audience across social media platforms, because we also have a YouTube channel. Upon finishing our discussions here on Facebook, we'll be moving the videos to our YouTube channel, so you can also search us, but we'll share the link as well. We'll also be sharing it to Instagram, to LinkedIn, various social media platforms. So the second purpose is to profile, because we understand that as young legal practitioners, it's not easy to break into the legal fraternity, which has centuries old of culture and customs. So we are living in a digital era, internet age, whereby a lot of our prospective clients, be it corporate establishments or individuals, trade unions, and the like, they are all on social media. We've seen how Twitter is actually impacting on the world. So we created a platform whereby legal practitioners will be able to engage with an audience and profile themselves, put their message out there, which is why we have a guest tonight, because she is also someone who has recently established a law firm. So we'll also be giving her a chance to talk to us and to introduce herself to you guys, because some of headlines are watching this live. Some of headlines will be watching this live tomorrow and days after that. So the third purpose for creating this platform is to provide a tool, a marketing and advertising tool. As I already said in the last point, that we live in a digital era. We live in an internet age whereby a lot of business is concluded, is negotiated, is entered into on the internet. So it's only fitting that even us as legal practitioners, we have podcasts and discussions on the internet, because that's where most people spend their time. That's where even multinationals make their major company announcements. So we saw it fit that let's create a platform where we'll invite various guests and we'll receive guests on a weekly basis, where we'll be publishing articles written by us from Setlago attorneys and our various associate firms, as well as any person, any legal practitioner or a professional who has an interest in law can write to us and ask us to either have them on a show as a guest or to publish their work, you know. So the show will be primarily for legal practitioners, both advocates and attorneys, but it will also be open to other professionals who have an interest in law. So yeah, that's why we are here tonight. That's why we created this platform, and we thank each and every single one of you who is tuned in, who's still going to watch. So without wasting much of your time, because I already see there's already 20 minutes of the clock, let's dive into it. So the first point of discussion is deceased estate. So what happens when a person dies? In fact, what is an estate? So an estate is a collection, or is a collective of a person's property. It can be cars, a house, a land. It can be a bank account. It can be anything that you consider an asset or a liability. So it's a combination of assets and liabilities that a person accumulates during their lifetime. So when a person dies, a deceased estate comes into existence, because now when you are still living, it's an estate, but the moment you pass on, we call it a deceased estate. Because remember, just because you are dead does not mean that your company is dead. Just because you are dead does not mean that your debts are dead. Just because you are dead does not mean that the bank can keep your money. So when the moment you die, your deceased estate comes into existence. So now, a person can either leave a will, which we'll discuss later, or they can die without a will. A will being a document in which a person writes their wishes and intentions in terms of how their property must be dealt with upon their death. So when a person dies, the first thing we do is we have to establish whether the deceased had a will or the deceased died without a will. So when you die with a will, your property will be dissolved or will be distributed according to what you wrote in your will. If you die without a will, we say you died intestate, and your estate will be administered and distributed in terms of the Interstate Succession Act 66 of 1965 as amended. So the first question is this: when it comes to estates, is that which deaths must be reported to the master's office? Because when a person dies, their death must be reported to a master's office. But which death? So the first one is, if a person dies within the Republic of South Africa and has left property or a will or any document which was intended to be a will, then their death must be reported to the master's office. The second one is that if a person dies outside the Republic of South Africa, but they leave a will or property in the Republic of South Africa, then their death must also be reported to the master's office. So if you die while you are staying in South Africa and you have a will or property, your estate must be reported to the master's office. We'll get to which master's office in the next couple of points. If you die while you are outside the Republic, maybe you were living in Zimbabwe or you were living in America, but then you left a will or property within the Republic of South Africa, then your death must also be reported to the master's office. So where do you report the death? So now, the first point is, if you were living in the Republic, if you were living in South Africa at the time of your death, or if the person who has died was living in South Africa when they died, so now their death, the estate, the late estate, must be reported to the master's office within whose area of jurisdiction the person was living 12 months before dying. So for instance, if you live in Polokwane, or if you were living in Polokwane 12 months before you died, or the person was living in Polokwane 12 months before their death, then their deceased estate must be reported to the master's office in Polokwane, which would be at Polokwane High Court. Likewise, if you were living in Venda, or you were living in Boksburg or Soweto, Pretoria, your estate, late estate must be reported to that particular master's office. So, if you were living outside the Republic, so if someone died while they were living in America or in Zimbabwe, but they had property or they left a will in South Africa, so the estate can be reported to any master's office. So if you are living in Zimbabwe, it can be reported Polokwane Master's Office, Joburg Master's Office, Pretoria Master's Office, Cape Town Master's Office, whichever one your beneficiaries elect to report the estate to. But now, in as much as it can be reported to any master's office, it must be reported only to one master's office. Cannot be reported to Polokwane Master's Office and then you go and report to Pretoria Master's Office, or you go to report to Cape Town Master's Office. So it can only be reported to one master's office, but whichever one. But with the first scenario where someone dies while they live in the Republic, their deceased estate or their late estate must be reported to the master's office in the area, or the master's office who has jurisdiction in the area where the person was living by the time of their death. So when, the next question is, when must an estate be reported? Or rather, yes, by how long must it be after a person dies that their estate must be reported? So the answer is the estate must be reported within 14 days. 1-4. Within 14 days of the person being dead, their estate must be reported. But obviously we understand that people, they grieve, and we know we respond to death differently. So even if a month has passed, that does not mean that the estate can no longer be reported. The estate must still be reported. It can be reported, it must be reported within 14 days, but it can be reported even beyond that. But obviously, the master's office might demand answers in terms of why was the estate not reported timelessly, you know. But then, as I said, people respond to death differently. Some they grieve for longer, some they need to deal with the laws in their own ways. So you may find that everyone is disorientated and the 14 days passes, you know. So it's not a train smash if 2 weeks has passed and the death has not been reported. It can be reported even after a month, but then with explanations should the master's office demand that an explanation be given. So by who can report a deceased estate? It can be reported by any person who has authority over property or is in possession of a document which is a will or which was intended to be a will. So any person who is in control of property which belongs to the deceased, or is in possession of the deceased will, can report the estate. So it can be the surviving spouse, it can be the children, it can be an uncle, it can be the parents, it can be the siblings. But any person who has control over the property of the deceased or is in possession of a will. So for instance, me being a lawyer, I draft wills, and you find that some of my clients, they elect me to safekeep their wills. So when they die, I'm in possession of the will. So should no one report the estate, I also have authority to report the late estate to the master's office because I'm in possession of a will, you know. So and how, this is the most important part now. I'm not saying what we've been discussing so far is not important, but this is where I want you to take out your pens and take notes, because, you know, normally when people come through to our offices, when they call us, when they email us, when they want to consult with us regarding deceased estates, you realize that they have absolutely no idea in terms of what documents are required, how can they report the deceased estate. So basically they just come and say, Mr. Setlago, our father has passed away, he had a house, he has cars, he has investments, and we want to know what are we supposed to do in order for us to gain control over his estate, you know. So how do you report a deceased estate to the master's office? And by the way, thank you for those who are tuned in. We appreciate you. We really appreciate you taking your time, joining us, and the intention is to teach, is to educate, but most importantly is to share knowledge in terms of the law, and precisely the law which affects all of us in one way or another. So we appreciate you taking your time to join us. If you have questions, please post your questions in the comment section, and we'll go through them as we go along with the discussion. If you have an opinion, please post an opinion in the comment section. If you have an experience that you would like to share, please also post in the comment section, because we are here to engage. In as much as I'm the host, I'm imparting knowledge, but I'm here to engage with you guys. So please engage with us in the comment section. So moving on, how do you lodge a deceased estate, or rather how do you report? What does the master's office need for you to report a deceased estate? There are various documents, but then it depends on the size of the estate. So the type of documents which are required, they're slightly different, but they depend on the type or the size of the estate. So you report if the value of the estate, the properties combined, it can be cars, the land, houses, investment accounts, life policies, it can be all of the assets belonging to the deceased estates. If the value of the properties combined, they are over 200,000, I mean, if they are 250,000 or more, if the value of the properties combined, they are 250,000 or more, you need to have the following documents. You will need the following documents to lodge the deceased estate with the relevant master's office. Excuse me, but we need to keep hydrated, especially because I've been speaking non-stop, so I'll be taking some regular sips of water. Okay, so the first document that you need, so if the property is 250,000 or more, you need 9 documents. You need to have 9 documents to report that particular estate. So the first document that you need is a death notice, which is form J294. So the death notice, the form, you will get it from the master's office, and then you'll need to fill it in. That's the first document that you need. It's a death notice. The second document is the original or certified copy of the death certificate. Original or certified copy of the death certificate. That one, unfortunately, you don't get it at the master's office, but the funeral parlors, they normally provide it. I think also the Department of Home Affairs, they also issue it out. So document number 3, I hope you are taking notes. Document number 3, but the podcast will be available after this, so you can always come back and watch it if you missed some of this. So first document, death notice. Second document, original or certified copy of death certificate. The third document that you need to have is a certified or original certified copy or original marriage certificate, if it's applicable. If the person who has passed on was married, be it the wife or the husband, then you need to have the original or certified copy of the marriage certificate. So, for instance, in customary law marriages, we normally see that people don't register their marriages. And that then obviously means that if your customary law marriage was not registered in terms of the Recognition of Customary Law Marriages Act, that means you won't have a marriage certificate. And you find in most cases that when a customary law wife who was just married in terms of tradition or traditional wedding does not have a marriage certificate, and they go to the master's office to report the estate, the master's office will obviously ask in what capacity, and you say, I'm a surviving spouse, and the first thing they will request is the marriage certificate. So you need to have the original or certified copy of the marriage certificate. If you don't have it, it's not a train smash again. You can submit any proof that is acceptable as proof of marriage to the master's office. But it's the discretion of the master's office to accept or reject such proof. For instance, one can say, I will submit the lobola letter or any proof that I was married to the deceased in terms of customary law marriage. And the master's office will say, no, that does not serve, it's not equivalent to a marriage certificate. So what you can do now, which is a discussion for another time, but I will just briefly touch on it. What you can do is through a lawyer, you can bring an application to the High Court and ask the High Court to give a judgment or a court order that verifies the existence of your marriage. And then with that court order, you will take it, you go to the Home Affairs Department, and then they will issue out a marriage certificate, even after your spouse has passed away. So if your father passes away and was married to your mother in terms of customary law, and your mother goes to the master's office, they say you don't have a marriage certificate, she can bring an application into the High Court to have the marriage verified, take the judgment, go to the Home Affairs Department, and then at the Home Affairs Department, they issue a marriage certificate. Only then will she be able to go to the master's office to report the estate. So that was document number 3. Document number 4, you need to have all original wills or codicils or any document that was intended as a will. So if a person dies and they had a will, you need to also submit the will when you are reporting the estate. If the person died without a will, then obviously there is no will. You'll state that the estate is intestate. So basically the person died without a will. Document number 1, death notice, original or certified copy of death certificate, original or certified copy of marriage certificate if the person was married, or all original wills or codicils if they exist. Document number 5, next of kin affidavit. Sure, a lot of us we understand what is a next of kin. You know, normally when you fill forms, they say next of kin details. So someone who was a next of kin to the deceased will have to write an affidavit stating that they are next of kin and that the person died, maybe even give out the details, and then state that there is a will or there is no will, there are heirs or there are no heirs or beneficiaries. That's document number 5, next of kin affidavit. Document number 6 out of 9 is that you must also submit a completed inventory form. So on inventory form, you will need to have a list of assets that the deceased person owned. So the inventory form will have all assets or all known assets. So the assets which belong to the deceased that you know must be listed. The liabilities, be it the debts and everything that the deceased person was owing, must also be listed. But then you can only list things that you are aware of. If you don't know that the deceased had a life policy and at the time of filling in the inventory form, obviously you can't put it in. But then you might discover it while you are going through documents, which means you'll obviously have to submit an amended inventory form to the master's office. So document number 6, you complete inventory form. You list all the assets and liabilities of the estate. And then document number 7 is something we call nominations by the heirs of an executor. So the people who are supposed to benefit from the deceased estate. It can be the spouse, it can be the children, it can be the parents, it can be the siblings, it can be a nephew, it can be an uncle, whomever has an entitlement to benefit or to inherit from the deceased estate, be it through a will or intestate succession. Then those people, let's say for instance, the deceased, who was a husband, had a wife and 2 kids. So now the heirs, it's the wife and the 2 kids. So the 3 of them will need to do nominations. But obviously we are talking about people with capacity. So let's say it's a wife and 2 minor children. So obviously the mother is the natural guardian. She will not act even on behalf of the kids. So the heirs or the beneficiaries of the estate will have to make written nominations. They will have to nominate someone who they want to be an executor. So an executor is someone who will have the powers to administer the estate, whether to sell property, to collect monies from the banks, from the pension fund, from whatever. Anything that needs to be done with regards to the deceased estate will be done by the executor. So then the beneficiaries, the heirs, they will need to nominate an executor, or even more than one executor. Let's say maybe there are 6 children whose parent has died and left properties and a whole entire estate. So maybe out of the 6 children can elect to nominate 2, to say we nominate our big brother and our big sister to be co-executors of the estate. So when the master's office issues out either a letter of authority or a letter of executorship, they will then, in fact in this case it will be a letter of executorship, because the estate will be more than 250,000. But the master's office will issue out 2 letters of executorship to those executors. So that's document number 7 out of 9. Document number 8 that you need to have when you report an estate will be completed acceptance of trust as executor. So the previous document number 7, we are nominating someone or people to act as executors. We nominate them, but they have to accept the nomination. So just because we nominated our big sister and brother does not automatically mean that they will be appointed as executors. They need to accept the nomination. So document number 8 is completed acceptance of trust as executor. The nominated executors or executor will have to complete or do a document to accept the trust as executor, and to that they will need to attach a certified copy of their ID. Document number 8, acceptance of trust as executor plus the ID copy of the person who is accepting the nomination as an executor. So the last document, document number 9, is undertaking and bond of security. This is the last document. So for instance, I'm a lawyer or I'm a legal practitioner, or there is an advocate. So now if the family or the heirs, the beneficiaries, in their nomination of executor, they nominate me as their lawyer to act as the executor, I also have the authority or the power to accept the nomination. So if they nominate me, then what the master's office will request from me, or rather demand from me, or require from me, is that I will have to issue an undertaking that I'm accepting the nomination, 1, 2, an undertaking that, and bond of security that I will administer the estate properly. So now, a bond of security, it can be an amount of money that the master's office will set, or it can be maybe property as collateral or as surety. So that, and the reason they require this, it's so that, for instance, depending on the size of the estate, the master's office can say, since you are going to be administering an estate which is worth 5 million, we want bond of security of 500,000 or maybe 1 million. I am not sure about the amounts. I might be wrong, and I'm hoping if I'm wrong, then my colleagues will correct me in the comment section. But the master's office will set the amount, and the purpose is to make sure that I will fulfill my mandate properly and appropriately. So basically it's security. Once I'm done administering the estate, the money will be paid back to me, you know. But the bond of security, the amount of money or property that must be submitted into the master's office, is only required if I'm a lawyer or someone else. But it cannot be required from the following people. If the will states that the executor, who is so and so, must not furnish bond of security. If the will states that I don't have to pay it, then I don't have to. Yes, I see Mangune Tulisa Kontlo is requesting. Please be on the line. I just want to finish up with this discussion, and yeah, maybe you want to join me on it, but then please just give me a chance to wrap up the points that I want to make. Not left with much, and then I will edge you on the live, so please request again. And so if the will says that you don't have to pay bond of security, then you won't have to pay it. If you are a parent of the deceased, you won't have to pay. If you are a surviving spouse, you won't have to pay. If you are a child of the deceased, you won't have to pay. So no money can be requested before you are appointed as executor. So just a quick recap in terms of the documents. Where you are reporting an estate worth 250,000 or more. Document number 1, death notice, original or certified copy of death certificate, original or certified copy of marriage certificate if applicable, if you were married or if the person was married, all original wills if they are available, next of kin affidavit, completed inventory form, nominations by the heirs, acceptance of a trust as executor, and undertaking and bond of security. So let's move to the next point, where you are reporting an estate in which the properties are worth 250,000 or less. So now in this estate, let's say for instance there's an RDP house which is worth 200,000. That's the only asset that the deceased person had. Or you are reporting an estate where there's only a cash amount, maybe a cash amount of 150,000, or maybe there's only one car which is now worth less than 250,000, or there are cows which are worth combined, obviously after valuation, they are worth less than 250,000. But whichever properties are in the estate, as long as they are worth less than 200,000, these are the documents that you must submit. In fact, you'll realize that 90% are the same. So I won't really be explaining, I'll just be listing them. If you are reporting an estate with a value of less than 250,000, you need to have a death notice. You need to have an original or certified copy of the death certificate, original or certified copy of the marriage certificate if the deceased person was married. If the deceased person was married, you need to submit a marriage certificate. And then number 4, you need to submit all original wills. If the person who has passed away had a will, if the deceased had a will, you need to also submit the original or any document that was intended to be a will. And then number 5, you need to submit a next of kin affidavit if there is no will. And then a completed inventory form, a list of creditors of the deceased, if applicable. So if you know, maybe for instance, that the deceased was owing maybe a car, or was owing a loan at Capitec, or was owing someone a shop, maybe a furniture store, he was still paying for furniture, you need to list the creditors. That you know, obviously. As I said, you can't list things that you don't know. You also need to submit the nominations by heirs. You also need the undertaking and acceptance of executor. So those are the documents that you need to have for you to be able to report an estate. So now, when you are dealing with an estate that is 250,000 or less, the value of the assets in the estate, they are 250,000 or less. The master's office, once you submit all these documents that we've just discussed now, the master's office will issue what we call a letter of authority. A letter of authority. So with a letter of authority, it allows you to now start administering the estate. The first thing that you need to do as an executor of the deceased estate, you need to go to a bank and you open an estate account. That's the first thing you do. Once you receive a letter of authority or a letter of executorship, you go to a bank, you open an estate account. So the purpose of the estate account is that all the monies that you will be collecting, either from the pension fund, from life policies, from other banks, from anyone who owns the estate or anyone who has assets belonging to the estate, that estate account, all the monies that you are going to be collecting will then be deposited into the estate account before any distributions can be made. You are not going to collect money from pension fund into your own personal account. No, we don't do it like that. You need to open an estate account, because that way it becomes easier to account. Because remember, whatever you do as an executor, you need to report to the master's office. So they will ask you, okay, you received 2 million from a GEPF, the Government Employees Pension Fund. Where is the money? What did you do? So you can't just receive money and then go and buy a car or a house. You deposit the money into the estate account. And then once debts are paid and everything, so if you pay a debt, then there must be proof. You can't just be taking 200,000 cash or 5,000 cash and then you decide to pay that mashone who the deceased was owing. There must be documentary proof. Every single cent must be accounted for. So that's the purpose of the estate account. Now, if, for instance, the father has passed away and the children need school fees or they need money for food, the surviving spouse, the mother, needs money for food, for school, for transport, for living essentials, all the other expenses that the father was taking care of, what they can do is that they can make an application, even through the executor, to the master's office, state that they need this amount of money for these reasons. Say, master's office, the surviving spouse and the children, they need 5,000 for groceries and transportation and whatever else that they need the money for, but you need to justify. Then the master's office will obviously give you permission to say, no, it's fine, you can withdraw the money. You know, because we see in most cases that the children suffer while the estates are stuck. You know, you find that people the children are suffering because maybe the grandma is holding on to money, or the grandma who is in charge of the estate is not doing anything, or the monies are still at the pension fund or stuck at FNB because the accounts are frozen, you know. So while you are collecting the monies and you are now in possession of some monies, maybe you collect. Apologies for that. There's a call coming in, but I'll try and call them back as soon as I possibly can. So yeah. Oh, man. So now once there is money that you have collected, you don't just spend it. You don't just say the mother needs food, the children need to go to school. You need to submit a request to the master's office to say, Master, the children need food, the mother needs money for transport. Can I please get access to such and such an amount? Then obviously the master's office, depending on your request and maybe the proof or whatever, if they are satisfied. Welcome back, or welcome me back. I'm sorry about that as well, network issues. But yeah, so that's how you do it. The children must not starve because money is stuck at FNB, or money is stuck in the estate account, or money is stuck at the government employees pension fund, or whichever provident fund. You can submit a request to use whatever monies you collect. But the most important point is that you don't just spend money that you receive. You need to be given permission by the master's office. So now, let's say, in fact, let's discuss something that is very interesting with regards to deceased estates. Customary law. You know, in most cases you find, guys, I'm sorry again. I was actually using my own data. I've just connected to the Wi-Fi now. So hopefully you don't give us any more trouble. But as I was saying, I want us to have a discussion, very controversial one, which affects most of us, you know, when it comes to customary law marriages, you know, whereby people are married in terms of traditional marriages. There are no marriage certificates. Maybe someone they just paid lobola and then they had a child, you know. So we have these cases almost on a daily basis where people are fighting. The mother of the child is saying the child's father's family, they don't want me to get anything, or they don't want my child to get anything. My child is not getting anything. They are not even maintaining my child. The properties, nothing is happening to them. Or maybe the uncle or the mother-in-law, the siblings, they refuse with the estate. So that happens a lot in terms of customary law marriages. So I just want to do a quick discussion in terms of what can you guys do if you find yourself in such a situation, or you know someone who is in such a situation. So now, let me just start by mentioning who are the beneficiaries in order of preference in terms of customary law marriages. So if you are married in terms of customary law, and then your husband dies or your wife dies, and there is no will, there is no marriage certificate, and all of these other things, who must benefit before who? Number one, the spouse. The surviving spouse is the number one beneficiary. I repeat, the first beneficiary at the top of the list is the surviving spouse, either the surviving wife or surviving husband. That's the first person who has to benefit. Number two, descendants of the deceased. Children. Descendants, children. So for instance, if a person dies and they are only leaving a child or children, two children, or let's just use a scenario where there is one child, even if they were not married to the mother of their child. So I die, I had a girlfriend and a child. The girlfriend not necessarily entitled to benefit because they are not a surviving spouse. But the child is the only person who must benefit. So the entire estate, all the properties will go to that child of your girlfriend or boyfriend. I think I need to repeat this. It's interesting. So, I repeat, if I die today and I have a child with my girlfriend, not married to her, I die today, I leave a girlfriend and a child. My child will be the only person entitled to benefit from my estate. So if I have 70 companies and 3 million and 5 cars and investment accounts, life policies, all of them will belong to the child. Obviously, the girlfriend will be acting as the natural guardian and mother of the child. So she will be in charge of the process. But the beneficiary will be the child. Not the child and my mother and my brother and my sister. And no, the child. I think you guys need to seriously take note of that. If I die intestate, remember I'm discussing a scenario where there is no will. If I die intestate and I'm married in terms of customary law, the only person who's going to benefit is my child. If I die, I don't have a surviving spouse, I don't have a child, then one or both of my parents, not my brothers. Remember, I said in order of preference. So at the top of the list is my surviving spouse. Number 2, if there is no surviving spouse, but there is a child, the child will take everything. If there is no child, there is no surviving spouse. Number 3 is the parents or parent. So now, this is where it gets complicated. If I leave both my parents behind, both of them in equal shares, will benefit everything. But if I leave one parent and 2 siblings, then that share that was supposed to be received, let's say for instance by my mother, will then go to my 2 siblings in equal shares. It's a long tree. I won't really dwell much into what happens if there were 2 siblings but one died but he had 2 children. We'll discuss that another day, or I'll write an article about it. But that's it. Number 3, parents, or one parent and siblings. But number 4, if I die and I don't leave a surviving spouse, I don't leave a child, I don't leave parents, then my siblings, be it my brother or my sister, doesn't matter, adopted, half brother, whatever, it doesn't really matter. But if I die and I leave my siblings, whether they are 100 or they are 2, they will benefit in equal shares. If I die, I don't leave a spouse, I don't leave a child, I don't leave parents, I don't leave siblings. That's when now we come to uncles and whatever, another relative, as long as they can prove that in one form or shape they are related to me. You see? So the uncle can't just come and take everything. We start with the wife, then the child, then parents, then siblings, and then uncle and auntie and whoever else. So to those uncles who are taking their Mchana's properties, stop. 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 But anyway, so that was the discussion with regards to deceased estates. And for the interest of time, I don't think we are going to go to wills. So what will happen is that it's either I will do a recorded session with Miss Millicent Mahlaban, who was supposed to be our guest tonight, and then have the discussion in terms of the Wills Act, and then we'll upload it for you guys. Or maybe next week we'll have her or yeah, have a discussion in terms of wills. But for now, I will add Mankune to Lisa Gondro because she wanted to be in earlier on. So please accept. Yes. Thank you guys so much for joining us tonight. Thank you for watching. Oh, okay. Well, I see the invitation was declined. Maybe she's not ready anymore. Maybe I answered her question. But yeah, she will request if she needs to come. But so that was it. First episode of Talk Law with Monare. Monare is me. Talk Law with Monare, simplifying the law for you. So that was the law simplified. I'm not sure. I used plain English. I didn't use lawyer language. If I did, forgive me. But that was our very first episode of this podcast. I look forward to many more with you guys and more audience. So please share, spread the word, share the link, share our page, and share the video if you're able to download it to your friends, your families, your colleagues, and your loved ones in general, because the content that we discussed today, all of us, at one stage or another, all of us are faced with it. So thank you guys for joining me. I hope I was a great host. Forgive me for the technicalities in terms of network. But I hope you guys are staying safe, you're sanitizing, you are wearing your masks where you are required to wear your masks. But most importantly, you are taking care of yourselves. It was a lovely evening, a long hour, but a very short one because there's so much to discuss. But I guess that's the beauty of it. We are not here as a one-timer. Same time, same place, next week, same amazing people, same great energy, same vibe. Drink water, sanitize, keep safe, but most importantly, know your rights. So, this is where you can find us. Search Talk Law with Monare on Facebook. Search Kgwaedi Monare Setlago on Facebook. Search Setlago Attorneys or Setlago_attorneys on Instagram. Or just go to Google, type Setlago Attorneys Incorporated. Whatever comes up is us. Just click on it. It will direct you to who we are. But find us on all the social media platforms. I'm your host, Monare. Talk Law with Monare, simplifying the law for you. I'm signing out.